$12, that's what I noticed on a Tuesday morning while eating breakfast. $12 my bank had charged me for absolutely nothing. I almost ignored it. Almost. What I found when I didn't ignore it eventually put my name on a legal filing that affected 40,000 people. I'm not a financial expert. I'm not a lawyer. At the time this happened, I was a freelance graphic designer, living in a one-bedroom apartment, checking my bank balance the way most people do, occasionally, and with mild dread. The charge showed up as account maintenance fee, premium tier. The problem, I had never signed up for a premium tier. I wasn't on any premium anything. I had the most basic checking account the bank offered, the kind they advertise as free, with a small green check mark on their website. I called the bank that same morning, waited 24 minutes on hold. Spoke to a representative named, according to her, Melissa. Melissa told me the charge was valid, that I had been automatically upgraded to premium tier services 60 days ago. I asked when I had consented to that. She said it was in the terms and conditions I had agreed to when I opened the account. I asked her to point me to the specific clause. She put me on hold for 11 minutes and then disconnected the call. I called back. Different representative. Same answer. Valid charge. Terms and conditions. Have a nice day. So, I did what any reasonable person does when a corporation stonewalls them over $12. I went to Reddit. I posted in a personal finance forum explaining exactly what had happened. Within 6 hours, I had 47 replies. 31 of them said the same thing. It happened to me too. Same bank, same charge, same premium tier they never signed up for. Same Melissa, or whoever Melissa really was, telling them it was in the terms and conditions. One reply stopped me cold. It was from a user who said they worked in banking compliance, not at this bank, but at a competitor. They said what I was describing had a name. It was called a shadow upgrade, a practice where banks quietly move customers to fee-bearing tiers without explicit consent, burying the authorization in a terms update email that most people never open. They said it was potentially illegal under the Consumer Financial Protection Bureau's guidelines. They also said that if it was happening to the people in this thread, it was almost certainly happening to everyone in the same account tier. I had 47 replies in 6 hours. The bank had millions of basic checking account holders. I opened a new tab and searched for a consumer protection attorney. The attorney I found offered a free 30-minute consultation. I took it the next day. I brought 3 things: my bank statement showing the charge, screenshots of every reply in that Reddit thread, and a screenshot of the bank's own website still advertising my account type as completely free. The attorney was quiet for most of the meeting. Then she asked me one question. Do you still have the terms update email they sent you? I did. I had never opened it, but it was sitting in my inbox from 63 days ago. Subject line, updates to your account agreement. The kind of email every single one of us ignores. She opened it, scrolled, stopped. The consent to the premium tier upgrade was buried in paragraph 11 of a 14-paragraph email, in the same font size as everything else. No bold, no separate checkbox, no clear opt-out instruction. She looked up and said, "This is a UDAP violation, unfair, deceptive, or abusive acts or practices. And if they did this to you, they did it to everyone in your tier." She filed a complaint with the CFPB the following week. The investigation that followed identified 40,000 accounts that had been charged the same fee without meaningful consent. The bank issued a full refund to every affected account holder. They also paid a regulatory fine. My $12 came back. So did $12 for 39,999 other people. And my attorney's fees, covered entirely by the settlement. I paid nothing. The entire process took 8 months. I didn't get rich. I got $12 back and the deeply satisfying knowledge that I had been an enormous inconvenience to a billion-dollar institution. But here's what I want you to take from this, because this isn't really about $12. Banks, landlords, subscription services, insurance companies, they count on you not checking. They count on you not calling. They count on $12 being too small to fight over, multiplied across millions of accounts. The moment I stopped and asked one question, where exactly did I agree to this? Everything changed. You have a Consumer Financial Protection Bureau. You have small claims court. You have consumer protection attorneys who work on contingency, meaning they only get paid if you win. The system exists. Most people just don't know they're allowed to use it.